So the question is multiple registration always intentional? So can it happen unintentionally also? If yes, can you give some examples where people do that without knowing?
Right. Absolutely. It's possible to have multiple registrations because companies often have, more than one email address, and they create separate accounts. And sometimes maybe there's a team sitting in India and there's a team sitting here in the US. And it happens very often, actually, that they register for the same person twice. And of course, both the registrations then get denied. So it's possible to have multiple registrations and then get a denial on that. But also, there's another aspect of this, a more practical aspect that I wanted to bring to your attention. So when they're saying colluding with another company, how is USCIS going to prove that there is a collusion? In some instances, it might be very easy to prove, like they have the same office address, right? Or maybe the company owners are husband and wife, or something like that. Then it, of course, becomes very easy to prove collusion. But otherwise, I feel in the several NOIRs and NOIDs that we got, there is some phishing going on. USCIS is phishing and putting information out there and saying, oh, ABCD have together filed 300 registrations, and I see about 50 registrations are common among all 4 companies. So I'm saying that there could be another reason for this. It may not be collusion, because from what I found out, the company that approached me didn't know the other 3 companies. So either it could be that USCIS is just putting information out there, which is incorrect, or it could be that all of them are using the same recruiter. A lot of these recruiters are based out of Hyderabad, based out of these big cities, and they send you 100 resumes, right? And you're using the same recruiter. So it could be that you're filing a H1 and XYZ also is filing the same person's H1. And sometimes even the beneficiaries don't know, because the recruiter has the passport copy and is giving out the passport copy to you, and XYZ company is filing for John. So it's possible that collusion is intentional as well in this scenario. So just because USCIS is saying something, it doesn't necessarily mean that it's true. So when you get a NOID or a NOIR, there's no need to panic. As long as you haven't colluded, there is, of course, a way of responding to it.
Yeah, and do we need a client or even a project to file an H1-B?
Again, this is where Thomas and I agreed to disagree that night, and we had a lot of fun discussing it. But so I am a person who is very cautious by nature, and so therefore I advise my clients accordingly also. So if a client came and told me, Prashanthi, I want to file a skeleton petition, I want to see how it works, shall we do it? I'll say, go ahead, do it. If they say, I want to file 150 H1-B petitions, skeleton petitions, with nothing, no client letter, no I-120, nothing, then I would be cautious and say, look, I don't think it's a good idea. So it depends on what volume you're talking about, right? In general, I usually tell my clients to submit some kind of documentation to show that their employment is not speculative. Now, we were discussing about this with the IT serve decision, whether they debunked the notion of speculative employment or it's still in place. And I was saying that, when I started my practice during the Y2K time, 96, 97, 98, we would file skeleton petitions, just the I-129 forms, right? And petitioner letters and degree copies, and they would all get approved. There was no notion, even for IT consulting companies, of speculative employment, right? So after that, of course, this whole notion of speculative employment started coming in. But there was always the notion of having a bona fide job offer. But of course, it's up to USCIS how they decide to enforce this and how they decide to interpret what is a bona fide job offer and what isn't, right? For example, if you are a product development company or you're a law firm and you choose to hire a person, you don't submit any documents. We don't usually submit. We just submit the degree copies and at the most maybe a copy of the lease and maybe the website, and that's about it. Because they don't ask about whether it's a bona fide job offer or not in that context. So really, it's all about how to practically get a H1 approval in the easiest way possible, right? That's what we tell our clients. It's more a practice than it is the black letter of the law. So we usually advise our clients to submit something, some documentation, either a SOW or a contract or something. Now, I wanted to differentiate between two different things. They could be that you have 5 different clients and you have contracts with all those clients, so you have an ongoing requirements and business relationship with that client, and you're filing a H1. You don't have a job for Praveen, but you're most likely to get Praveen into one of those POs that you have, right? So that is not speculative employment, though you don't have a job exactly for him at that point of time when you're filing the registration or filing the H1, right? But on the other side, if you are filing a H1, you're an IT consulting company, you have no requirements at all, you have no clients, and you're filing a H1-B petition. It is speculative, and USCIS is going to say at some point after you file the 3rd case or 4th case or 5th case, they're going to ask you, what are they going to be doing? Same, I'll give you another example, sorry, just one quick point and then. Another example, when we talk about in-house project, right, and we give all this information. The reason we're getting RFEs is because they're asking about speculative employment. Otherwise, they wouldn't care, no matter what you submitted. And they should approve the H1 then. So just these few examples that I wanted to give.
Okay. I have this.
Another argument, and we love to argue, as you know, and play the devil's advocate. So I'm not disagreeing or agreeing with anyone. I'm just presenting a counter argument. So another reason I think that a vendor letter or especially in the IT consulting, we're only talking about the IT consulting scenario, where a vendor letter is useful is in the context of specialty occupation. Now we know specialty occupation is alive and kicking, and they want to know what the job duties actually are. It's not about the job title. Just because you say software engineer doesn't mean it's a specialty occupation. They want to look at the job duties. And in order to look at the job duties, they don't want the petitioner to tell you what the job duties are. If you're working at another work site, they want it from the horse's mouth. So another useful aspect of a vendor letter or necessary aspect may be that you're asking the vendor or the end client to put in what the job description is so that there's no question about whether the job is a specialty occupation or not. It's just another point.
All right. Thank you. Prashanthi, I have a question. So, can the employer still file with level 1 wages? What's your opinion on that?
I don't see why not. It depends on every individual case. There is a certain way that you calculate the levels, right? Level 1, level 2, level 3, level 4. So as long as your case or the job is coming within that calculation, there's no reason why you can't do level 1. For example, if he has a bachelor's degree and is a fresh graduate, that will most probably be level 1. And we were getting RFEs, like all of us were getting RFEs, right, at some point of time, but I'm not seeing any RFEs for level 1 issues anymore. So the answer is yes.
Okay. Can the employers still use the SOC code of computer programmer, a programmer analyst? Because we know the wages have gone up for software developers and all. So can they still use programmer analyst?
Yes, because something magical happened with the SOC codes and program analyst, systems analyst. I don't know how many of you actually noticed, but the job description itself changed. And for example, for systems analyst, they put in the job description itself, design complex programs, blah, blah, blah. So they put in the language that you usually put in if a job is a specialty occupation. So that gives me a lot of hope, and we have filed a lot of program analyst, systems analyst cases after the new SOC codes came out, and they were all approved. So I'm very hopeful about going back to filing systems analyst case.